everyone. We'll be getting started in just a few moments. I just wanted to check and make sure that Jennifer Nagda, our co-presenter, can hear me and is on the call.
Jessica, I can hear you, and I'm on the call. Thanks so much.
Wonderful. Thank you. Okay, hello everyone. We're going to get started. It's exactly 2 Central Time, so I wanted to be sure that we're in schedule here. So hello and happy Friday. Thank you so much for joining our webinar today. My name is Jessica Brown. I'm the Development Director here at the Young Center. Some of you may have joined us a few weeks ago for our webinar, which is called The Changing Landscape for Children in Immigration Proceedings. That webinar gave a pretty detailed overview of our work here at the Young Center and painted really a broad picture of the many threats that are facing unaccompanied children today. This webinar is currently available on our website for those of you who would like to watch that later. We really see today's webinar as a natural follow-up to this first one. There may be some slight overlap for those of you who joined us previously, but really today we're focusing on one specific threat that's facing our kids, and we'll be focusing on a case the Young Center has been involved in. This session today will last no more than 45 minutes, which will include just about 5 minutes for Q&A at the end. A little bit of an overview of how we'll proceed today. First, our Policy Director, Jennifer Nagda, will review the current proposals that we're most concerned about that would affect immigrant kids, and she'll provide us with some recent updates there. Then Marisa Chumel, our senior social worker, will provide an overview of one of the cases that the Young Center is working on, and then back to Jennifer, and she'll let us know some of the things that we can be doing about this. We will have time for a few brief questions at the end. You can submit those using the chat function on the left bottom side of your screen. And note that due to confidentiality, we're not going to be able to answer any specific questions about the case that we present. And I think that's it for my intro. So thank you again for joining us. And with that, I'll turn it over to Jennifer.
Jessica, thank you so much. It's terrific to have the chance to communicate with so many people again, and we do encourage you to please submit your questions so that at the end we can make this as much of a conversation as a webinar allows us to have. And for those of you who are on the East Coast during this webinar, there are some pretty terrific storms going on, so if you hear some thunder in the background, I apologize, but you may be experiencing the same thing right now. So what we wanted to do today was really focus on this issue of threats to separate forcibly children, immigrant children arriving here at the United States borders with a parent or parents and other members of their family. I think the idea that the government would forcibly separate a migrant child from her mother or her father is a fairly terrifying one. As many of you know, in regular child welfare proceedings, when a state government is considering whether it's appropriate to separate a child from a parent, perhaps because of suspicions that the parent has abused or neglected the child, there are countless safeguards in place to try to make sure that the separation happens only in the most serious cases. Safeguards that require decisions to be made by impartial judges and that require the children and their parents to have an attorney and so on. And in fact, federal law requires state child welfare systems that are receiving federal money to work constantly toward the reunification of the child with her parent when they've been separated as a result of government action. For years, though, at the Young Center, we've worked on cases where immigrant children arriving with a parent at the U.S. border, both mothers and fathers were separated from that parent by immigration officials. And we know from our experience that the safeguards found in state child welfare law simply don't exist for families who are caught up in immigration enforcement. Children who are separated from a parent don't get to ask a family court judge or an immigration judge even if they can be reunified. And neither the children nor their parents have a right to government-funded attorneys for any part of their immigration case if they can't afford to find their own attorney, notwithstanding the liberty interests and other interests that are at stake. And so that's what made the month of March, this past month that unfortunately concludes today, so particularly concerning for all of us who work with immigrant children arriving here and seeking protection in the United States. So in early March, the Secretary of the Department of Homeland Security, which is responsible for many things including immigration enforcement, Secretary Kelly, made a statement in a CNN interview that his agency was considering a plan to separate immigrant children from their parents when they arrived at the U.S. border, not because there was a concern about the child's safety at that moment, but to attempt to scare other families from making the same migration journey. In other words, to deter other families from seeking protection in the United States because of threats to their children's safety and well-being in their home countries. Advocacy groups, including the Young Center, you will be happy to learn, organized quickly. Among others, the Women's Refugee Commission drafted a letter laying out both the legal and moral obligations to children who arrive with parents, and nearly 200 national organizations joined in that letter, which was sent to Secretary Kelly last week. Non-immigration groups also weighed in quite vocally. For example, the American Academy of Pediatrics released a statement decrying any plan that would take children away from their parents and how that would directly impact their health and well-being. And members of Congress who, almost without exception, maybe one or two, who were all women, also weighed in. And in particular, Senator Feinstein of California sent a letter to Secretary Kelly asking him to meet with her and others and to explain his plan and his rationale for that plan. Unfortunately, a couple of weeks ago, Secretary Kelly doubled down on this threat, for lack of a better term, and repeated that it was a plan his agency was considering in a closed-door meeting with members of Congress that was subsequently reported to the press. On Monday, the Congressional Women's Working Group on Immigration, comprised of women members of Congress, held a public forum to bring attention to this issue and to the broader issue of parent-child separation. We'll talk a little bit more about that group at the end of today's webinar. But for a moment, we have some good news to report, and that is a victory. On Wednesday, as it was reported yesterday, Secretary Kelly met with Senate Democrats and told them that the agency was no longer considering this plan. So without question, this was a big victory for children and families and advocates, and not surprisingly, it sent us scrambling as we prepared to refocus the content of today's webinar. That said, however, the threat of parent-child separation remains. And the purpose of today's webinar is for us to talk in a little more detail about what led to this proposed plan, and then to highlight some of the many cases in which children are already separated from their parents. We do expect that these cases will continue, and we will need your support in bringing these cases to the attention of policymakers and trying to end this practice. So what's driving the policy? Sorry, I'm going to attempt to move the slides forward. There we go. So we wanted to provide some very brief context for why we think this policy was proposed by a cabinet level member of the administration. Since 2014, about 2.5, almost 3 years ago, there has been a dramatic increase in the number of children and families seeking protection in the United States from persecution and violence in their home countries, and in particular, the Northern Triangle countries of El Salvador, Guatemala, and Honduras. As a reminder, presenting yourself at a country's border, including our country's border, and asking for protection from persecution is not an illegal act. Some of you may have heard me say this before, and I will continue saying it. But it's important that all of us be aware of the power of words and language and the current effort to create a narrative of criminality about immigrants. In any case, there is no question that many more families started coming to the U.S. seeking protection in 2014. But they didn't just come to the United States. Countries including Panama, Costa Rica, and Nicaragua also saw dramatic increases in Central American families seeking protection at their borders. In response to these changes, the United Nations High Commissioner for Refugees, or the UNHCR, conducted a study of hundreds of these children. And they also conducted a similar study of children and parents who were coming to the U.S. together, and in particular mothers. With respect to the children who were seeking protection here, the UNHCR found that a majority of these children were fleeing situations that would make them eligible for protection under international law. In the U.S., that means asylum. And I note from the webinar that the control panel on the left that I can see that at least one of the folks involved in doing the research on that project is on the call today, so I hope she'll chime in with some questions. But in any case, the vast majority of these children and families are not, they were not then and they are not now, trying to sneak into the United States. Rather, they're presenting themselves to border officials and requesting protection. I will not use our time today to talk about the conditions of their journey, which we have done before, which often involves traveling in small groups at the hands of smugglers or traffickers, or the violence in their communities that caused them to grab their children and flee in the first place. But I will ask you to imagine what it would take for a parent to make that decision, to then survive a many hundreds or thousand-mile journey through desert and mountain, and then to willingly turn yourself in to a United States Border Patrol agent. And then imagine what it would feel like for that mother or father to see their children immediately taken away from them without knowing what will happen to them and having, in all probability, absolutely no reason to trust a government official given their experiences in home country. I would argue that what has been missing from our public discussions about these families is an absolute lack of that imagination or empathy for these children and their parents. What isn't a matter of imagination are the facts surrounding our government's response to these families' arrivals. In short order, our government constructed a number of large-scale detention centers for these families. The first ones were temporary in places like Artesia, New Mexico, which you may have heard about. But by 2015, the government had two large permanent facilities set up and running, roughly an hour outside of San Antonio, Texas, in the towns of Dilley and Carnes. Those two facilities are operated by private companies. The government also increased its use of a longtime family detention center in Berks County, Pennsylvania, an hour or so outside of Philadelphia, which is run by a local county government. There's a wealth of information that is available on the terrible conditions of these centers, the myriad problems that arise when you lock up children with their parents, and some of the extreme cases involving the abuse of people at these facilities. And when we post this webinar to our website, we will include links to just a few of those many reports. But I do want to take a moment to highlight one report in particular, because it wasn't issued by an advocacy group, but instead it was issued by a group of experts who were handpicked by the Department of Homeland Security itself to review the family detention centers and offer recommendations. That report, which was released late last year and can also be found on the internet, provided 147 plus pages of detailed recommendations for immediate and necessary improvements to the conditions of detention for children held with their families. But those recommendations followed a preliminary recommendation that the agency stop locking up families because it was neither necessary nor appropriate, and because, and I quote here from the report, detention or the separation of family for purposes of immigration enforcement or management is never in the best interests of children. And again, I highlight that because that was a report that was released by the agency's own advisory committee on family detention. Not surprisingly, the detention centers have been subjected to several legal challenges over the last few years. I will take just 2 minutes to talk about a few of those challenges in the hopes of persuading you that our government's response to these families arriving at our border has been extremely problematic, not just from a moral or ethical perspective, but also under our laws and Constitution. But despite these legal challenges, the government continues to develop policies, including the one proposed this month by Secretary Kelly, that do or would harm children. So the first of these successful challenges boils down to the message of you can't lock up families to send a message. And this may sound familiar to you. This gets back to this issue of deterrence. When the government first opened new family detention facilities, members of the prior administration indicated that they were doing this in part to deter other families from seeking protection in the United States. This should sound familiar. It's the very same rationale that Secretary Kelly offered earlier this month. Yet a federal court in Washington, D.C. wasted no time in striking down that justification for detaining children and families as unlawful. The second successful challenge involved a different group of children, and the children we most often serve here at the Young Center, who are unaccompanied children. For years, children who arrive in the United States already separated from a parent, and again, these are known as unaccompanied children, those children have been eligible for special protections. Not many, as we've told you before, but at least a few special protections. When the government started detaining children with their parents, the government argued that these accompanied children who were with their parents had no right to the same child protection or child protective procedures as unaccompanied children. Once again, a federal judge in California this time quickly disagreed and required the government to treat all children in immigration detention the same and provide them with the same protections, as weak as we might argue that they are. The third successful challenge has happened very much at the grassroots and local level, and that has to do with the detention facility's failure to comply with state laws that generally govern the care of children in government custody. Advocates in both Texas, in the San Antonio area, and in Pennsylvania have challenged the operation of these facilities under state laws that require special licenses for facilities where children are held. And you can imagine the many reasons that we have all of these licensing and regulations around child welfare or the holding of children in government custody. In Texas, advocates successfully challenged the emergency procedures the state used to suddenly license the two facilities out of San Antonio as child licensed facilities. That process continues to be ongoing, and at the end of the presentation we will offer recommendations for how you can help the advocates who are trying to bring that licensing process to a halt in Texas. Similarly, Pennsylvania advocates successfully challenged the manner in which the Berks County facility was licensed and whether it could continue to hold children, not just for weeks or months, which is what happens in Texas, but for years. The Pennsylvania governor, as of even this week, has failed to respond to repeated requests to hold the county responsible for complying with state law. So despite all of these victories, we still see so many cases at the Young Center in which children are separated from their parents while they are in some phase of immigration custody in a way that would never pass muster if those children were in traditional child welfare proceedings. I am so pleased that my amazing colleague, senior social worker Marisa Chumil, is here today so that she can tell you about one of these cases and the work our colleagues at the Young Center did to help reunify this child with her mother. Before we wrap up today, I'll return very briefly to talk about what all of us can do as future threats arise to the child-parent relationship in immigrant families. But for now, I'll turn it over to Marisa.
Thank you, Jennifer. Due to the severity of these threats against the parent-child separation, the child advocate role remains critical now more than ever. Appointed by the federal government, the child advocate assumes an independent and objective role similar to a guardian ad litem. We advocate for the safety, well-being, and permanency of unaccompanied minors throughout their entire immigration proceedings. We weigh in on issues ranging from custody and placement to permanency through legal relief and safe repatriation. Here at the Young Center staff, such as social workers and attorneys, we train and screen bilingual and often bicultural volunteers to work one-on-one with the most vulnerable children. We receive referrals to work with childhood trafficking victims, parenting and pregnant teens, children with physical and mental disabilities, children who have severe trauma histories who are afraid to return to their home country, and even infants and toddlers who cannot express their wishes. Through weekly visits, the child advocates learn about the child's story over time. They build trust and rapport with the children, learn what the children want, help the child process information that they get through the complicated immigration system. Advocates empower the child to make informed decisions and ensure that decision makers hear the child's voice. We accompany the child to court hearings and asylum interviews and maintain confidential what the child imparts to the advocate during weekly visits. Based on the child's consent, we remain in contact with them once the child leaves the detention facility. We submit best interest recommendation letters to governmental stakeholders that make decisions impacting the long-term interest of the child, such as where a child will be allowed to stay or where they will return to. Our office headquarters is in Chicago, but we now have grown to 8 offices staffed with attorneys and social workers across the country that include locations such as New York, D.C., Houston, San Antonio, Phoenix, Los Angeles, and Harlingen on the U.S.-Mexico border. To highlight the irreplaceable role of the child advocate, I'd like to tell the story of Lupe. Lupe, whose name and country we did change for purposes of maintaining anonymity, came into federal custody when she was 2 years old. She was separated from her mother for a total of 14 months, which was a painfully protracted stay for her tender age, and spent nearly 1/3 of her life in federal custody, which was nearly as long as the time that she was in her mother's care. She had to celebrate her 3rd birthday in custody away from her family. But when Lupe was 2 years old, she and her mother arrived together at the border. Lupe's mother had fled domestic violence in Honduras to seek safety and to apply for asylum in the United States. Upon crossing the border, they were apprehended. Just 1 day after the apprehension, against the mother's wishes, DHS officials separated them. At the time of the separation, the mother was provided no reason for the separation. We only later learned that the separation was based on information subsequently determined to be outdated and incorrect. That separation stretched for more than 1 year. Immigration officials damaged the sanctity of the parent-child bond and threw them into a world of uncertainty, confusion, and anxiety. Lupe and her mother remained in that world of distress for more than 1 year. While Lupe's mother remained in ICE custody, she had no contact with Lupe and received extremely limited information about even where her daughter was located. Lupe, meanwhile, was determined to be an unaccompanied child, meaning a child without a parent or guardian, and was placed into the custody of the Office of Refugee Resettlement. In general, children placed into ORR custody were unaccompanied when they first encountered immigration officials, for example, when arriving at the border without a parent. In this case, Lupe was unaccompanied by the actions of immigration authorities who separated her from her mother before verifying that there really was a legitimate reason to do so. 3 months later, Lupe's mother was returned to Honduras after she was forced to sign deportation papers. Upon her return, Lupe's mother made several appeals that increased over time in frequency and urgency, asking her government in Honduras to intervene on her behalf and to secure Lupe's return. At no time did Lupe's mother ever waive her parental rights. Meanwhile, Lupe was transferred between 2 temporary foster homes in 2 different states, and throughout this time, ORR remained Lupe's physical custodian. Lupe's case was referred to the Young Center, and we were appointed as child advocates. And as mentioned, we are referred some of the most challenging cases. Lupe was an example of that. She was so young, and because of the manner in which she was separated from her mother. The duty fell upon us to determine whether Lupe's best interest would be better served by remaining in foster care in the United States, where she would face long-term, perhaps permanent separation from her mother, or whether she should return to live with her mother in Honduras. The Young Center commissioned an international home study of the mother in Honduras, and our work to conduct international home studies is not funded by the government, but rather through private sources. The goal of our international home study was to gather information on whether Lupe would have a responsible adult to return to, a safe home to live in, and to ensure that she would not be at risk of abuse, neglect, exploitation, or any other harms that would justify continued separation from her mother. The home study provider also assessed whether other services or supports would be needed if Lupe were returned. Our home study provider interviewed the mother, her family, her neighbors, her employer, and determined that Lupe's mother provided appropriate care, supervision, and support when they lived together, and that ultimately returning Lupe to her mother's care would not put Lupe in any risk. The mother had a network of social support, and during the interview with the home study provider, the mother talked about the harrowing separation from her daughter, showed her photos of her and Lupe together throughout Lupe's childhood. Mother had separated from the abusive partner and sought services, including therapeutic supports, through local agencies in Honduras. And ultimately, the home study provider confirmed there was no reason to believe that Lupe would be in danger. About 6 months into Lupe's placement in ORR, Lupe began to demonstrate behaviors of concern. In order for us to respond to those concerns that raised questions about potential safety risks, we convened a best interest determination panel. In cases like Lupe's that present critical concerns for the child's safety and well-being, such as a permanent separation between a child and parent against either the child's will or the parent's will, we convene best interest determination panels. We model this protocol from the United Nations High Commissioner for Refugees and its guidelines in determining the best interest of the child. The goal of those panels is to ask independent experts to review the cases with us and to develop a consensus opinion on what course of action is in the child's best interest. For Lupe's case, we had experts in childhood trauma, early childhood development, children and family rights, and country conditions. They reviewed the home study. They examined Lupe's case through the lens of best interest principles, such as the child's right to family integrity and the right to safety and a stable and long-term placement. The best interest determination panel conferred that Lupe's mother clearly established her willingness and her ability to access services, and the mother had proactively sought assistance from multiple governmental agencies for Lupe's return. Ultimately, the panelists recommended Lupe should be returned to her mother. Guided by the Convention on the Rights of the Child and Best Interest Principles, the Young Center recommended it was in Lupe's best interest to return to her mother. We supported the right that every child has to grow under the protection and responsibility of the parent, and that only in exceptional, judicially recognized circumstances would a child of such a young age be separated. At no time did any court with appropriate jurisdiction make a determination that the mother was unfit. The Young Center coordinated with the mother and with consular officials to ensure continued access to therapeutic and social support, both for herself and for Lupe as part of safety and transition planning. For weeks, video calls between Lupe and her mother were scheduled as an attempt to help them reestablish their relationship and encourage a positive attachment, which obviously had been quite strained as a result of their separation. Based on the best interest determination panel recommendation, the Young Center observed those calls. And in the meantime, a pro bono lawyer took Lupe's case and, following our recommendation, asked the immigration court to grant Lupe permission to return to her family. The attorneys representing the government joined in that request. An immigration judge granted the request and arrangements were made for Lupe's return. However, before that could take, the foster family where Lupe was living retained a private attorney without consent of the government agency tasked with Lupe's care and custody. That attorney sought to block Lupe's reunification with her mother by filing a motion in immigration court. The attorney also obtained an order from a state court purporting to appoint the temporary foster parents as guardians. If they had been successful, Lupe might never have seen her mother again. The foster family simultaneously asked the immigration judge to hold its decision to allow Lupe to return. At the Young Center, we meticulously looked at all of the case record, maintained constant contact with stakeholders from both countries, both at local and national levels. We submitted an additional best interest recommendation letter to the immigration judge explaining that the state court order was obtained in violation of federal law and that it was not in Lupe's best interest to be represented by the foster family or their attorney, and that Lupe should be allowed to return to her mother immediately. We worked to ensure that the government returned Lupe to her mother in a swift, child-friendly manner. For example, for us it was important that a female ICE officer in plain clothes accompany Lupe rather than a male officer in uniform. And in addition, we advocated that a female consular representative who was linguistically and culturally sensitive also accompany Lupe on the flight upon her arrival at the Honduran airport and as she reunited with her mother. So you may wonder, how is Lupe doing today? She was reunified with her mother earlier this year. We are happy to report. Her mother described that day at the airport as the happiest moment of her life. Lupe only spoke English for the past year and is just now starting to recall her Spanish language. She mainly communicates through signs and gestures. She does play with her siblings very well and likes reading books and playing with dolls and cars. Mother and Lupe go to counseling regularly, and with the help of the therapist, the mother created a visual schedule for Lupe to point to signs when she's hungry, tired, or has to go to the bathroom. The mother is also pursuing a scholarship for Lupe to attend a bilingual school. The mother was recognized by the Honduran government for her efforts to reunite with her daughter, and she continues to stand up against these injustices that have occurred of the parent-child separations at the hands of DHS. And Jennifer, if young center supporters and immigration rights advocates want to stand up against these injustices, similar to Lupe's mother, can you help us in what we can do?
Marisa, I would be happy to, and thank you so much for reminding me of everything that went in to Lupe's case and her reunification with Mom. I know Marisa said this at the beginning, but I'll repeat it for those of you who may have joined late or missed the comment, but we did change both Lupe's name and her country of origin to ensure anonymity, and of course the photo at the bottom of the slide is not Lupe and her mother, though Lupe is equally adorable to the child in this more anonymous photo. On the next slide, however, we do want to answer Marisa's question as to what folks can do, because this is the question that we often hear the most. And I think importantly, what is a priority is doing what you can to try and get your hands on the best possible and most accurate information, particularly in light of what I mentioned before in this sort of discourse and narrative of criminality. It can be very hard sometimes to figure out just what's going on. Groups such as the Young Center and other organizations that have long histories of working with immigrant and refugee populations, and particularly around these issues of child-parent separation, for example, the Women's Refugee Commission, which I mentioned earlier. For those who sign up on our websites, we do have listservs, an email distribution list where we send updates and provide links. And I know at the Young Center, we will provide links to policies that are released so that you can read the policy for yourself and decide what you think it means. We will provide links to court decisions or copies of court opinions so that you can review this information for yourself. Importantly, just this month, or perhaps it was right at the end of February, the Women's Refugee Commission, Lutheran Immigrant and Refugee Services, and several other organizations published a full report on this issue of child-parent separation while in government custody. And we'll provide a link to that full report online, which profiles many cases like Lupe's, where immigrant children were taken from their parents or denied reunification with their parents. Another thing that you can do related to what we've talked about today is to investigate and provide support to these challenges to the Texas and Pennsylvania-based family detention facilities. I doubt they will remain the only family detention facilities. In Texas, the group to reach out to is Grassroots Leadership. You will find them very easily with a Google search. In Pennsylvania, I would recommend that you look for the Shut Down Burks campaign. These groups are, or these campaigns have been led by grassroots organizations, community-based organizations who are doing extraordinary work with extremely limited resources to support the families who are there and simultaneously try to end the practice of locking up children with their parents. And of course, just maintaining contact, following and providing support to organizations, including the Young Center on our last slide will provide the link to our Facebook page and our Twitter account and websites. But I would stress that both financial support but moral support of any kind has been very much appreciated. So many of you have reached out providing messages of support, not just to Young Center staff, but even there have been folks who have been writing cards for the kids that we work with, just general messages of support and encouragement. And I don't think I could adequately convey what those messages do to lift our spirits and the spirits of the kids that we work with. And then, of course, volunteer in your community. The Young Center, as Marisa mentioned, has 8 programs around the country where we recruit bilingual volunteers to work directly with children. But there are so many other groups where you can volunteer your time either to help kids or families or to join in protest movements or to address issues that are arising in your community or nationally. And keep an eye out for grassroots efforts to protest in your communities. On one of the earlier slides, we had a visual from Mamas con Poder, or Moms Rising, which is a massive online campaign. Moms Rising, Mamas con Poder, tackles a wide range of issues, but they made this issue of child-parent separation a priority in the month of March. They held a Twitter campaign. They tried to bring a lot of attention to the issue, and we continue to talk with groups around the country. If something like Secretary Kelly's proposed plan were to go in effect, how could we create a grassroots uprising to something like this in a way that we saw so many people flocking to airports together to protest the Muslim ban, the refugee ban that was announced earlier in the year. And then the last thing you can do to help is to thank members of Congress who stood up and held the government accountable on this threat to forcibly separate children and mothers. As I mentioned before, Senator Feinstein wrote a letter that was widely circulated to Senator Kelly, and then Leader Pelosi, but then this group of the Women's Working Group on Immigration Reform, and we've listed their names there as well as some other names of individuals who held a forum this past Monday to bring attention to the issue. These are all people who stepped up and said, I'm appalled, I'm shocked, and this is something that really matters. I think it's very helpful when we provide recommendations or when we advocate with Congress people to take certain stances or to not take certain stances, but I think it's equally helpful sometimes just to take a moment and say thank you. So if these are your members of Congress, this would be a great time to say thank you to them for stepping up. And if your member of Congress isn't here, then perhaps the next time this issue is back in the public, you could ask them to join this group or ask them why they are not saying a lot about these issues. So I realize that those, there are sort of a large number of suggestions there, and there are lots of ways. We had planned today to potentially be in a position of doing something much more concrete, and I am frankly quite relieved that we don't have to do that in light of Secretary Kelly's statements a day or two ago in which he said he will not move forward at this time with that plan. So that's some really great news. But I know we have a couple of questions from those of you who've been listening so patiently, so we are happy to take your questions and see what we can do with the time that's remaining. Jessica, do you want to try and moderate our discussion here?
Absolutely. Thank you, Jennifer. That was really helpful. And Marisa, thank you too. I think everyone really enjoyed learning more about these issues and especially about the case that we provided services on. So thank you so much. So we have just under 10 minutes or so. We have a few good questions come in that I'm going to put out there, and either Jennifer or Marisa, feel free to jump in. The first question asks about what is the focus of the desired advocacy efforts? Are we focusing on the improvement of family detention centers so children can remain with their parents, or are we focusing on alternatives to detention?
So I'm happy to take a stab at this. Certainly on our end, and I think we were pleased to see that the DHS's own advisory committee made the statement that it's generally never in children's best interest to be detained. So absolutely, we don't want them to be separated. Most often, they're being separated during a very initial period of custody where the government is appropriately trying to figure out who they are, whether they present a security risk to themselves or to anyone else. We don't want them to be separated during that time, but if the government is going to take its time in making a decision about the parent or child's claim for protection, we don't want them to be detained. It is generally not necessary with respect to the parents in terms of who has actually been coming here, and it is almost never in the best interest of a child to be detained. And there are some good reports out there that demonstrate the cost effectiveness of alternatives to detention. Last year, the government implemented a program in which certain mothers were being released from the family detention facilities into a case management program that was designed to provide them with services and support. Unfortunately, the contract to run that program went to the same private for-profit corporation that also runs some of the detention centers. So there were, of course, some simultaneous concerns about that program. But the idea was that if you provide families with services, they're better able to integrate into the community and they're more likely to continue appearing in immigration court proceedings. And there are very inexpensive alternatives to detention. The cost of an ankle monitor, which, for example, the mothers who've been detained in Berks for over a year and who have said that they would be more than willing to wear ankle monitors which require them to be within a foot of a wall for 12 hours a day for charging purposes, that they would happily take those alternatives to detention rather than being locked up in the Berks County facility. So the long-winded answer to your question is, in general, we don't ever want to see children detained, and it is generally much more cost-effective for the government not to detain but to provide an alternative, but there can be adverse incentives depending upon the companies that receive contracts to operate these facilities and whether the government feels that it has an obligation to keep a certain number of people detained at any time.
Great. Thank you, Jennifer. And really quick, I just want to jump in. I don't think I said this. We're going to also have this webinar from today, the recording and the PowerPoint on our website as well, if not this afternoon, Monday. So just FYI, I know there's a lot of great information, so you'll have that, a record of that on the website. Jennifer, the next question is for you as well. Do you have a sense of what was persuasive to Secretary Kelly in changing the administration's plan to separate families? I'm wondering if fiscal interests, e.g. the behavioral, procedural, mental health cost of separation, may be more persuasive to his administration than humanitarian or ethical arguments?
Susan, that's a great question. If I knew I'd resign from the Young Center and sell myself out as a consultant to an organization that would hire me to be more effective in advocating with the Secretary, I really don't know. I think there's a possibility he was trying to gauge the type of reaction to his plan before trying to implement it, and that there was sufficient outcry and resistance that it was clear that it would not be worth it. I do think fiscal costs can very much play in. It also depends, though, on where the costs are allocated. So, when children are detained with their parents in these family detention centers, the cost is borne by the Department of Homeland Security. When children are separated and the parent is detained by the Department of Homeland Security and the child, like Lupe, is rendered unaccompanied, it's a different federal agency that then has the fiscal obligation, the fiscal burden to care for the child. So it's hard to tell, depending upon how much collaboration there is across agencies, what the motivating factors might be and what the fiscal considerations might be. So I think it's a fabulous question. I'm not entirely sure, but it does seem that with a lot of the ideas that have been proposed, the degree and strength of public reaction and the reaction of individuals outside of the usual suspects really matters. So yes, 200 immigrant rights organizations said you absolutely can't do this, but it may have been even more helpful that individuals in the community of their own accord, without necessarily any organizational affiliation, stepped up and said, this is outrageous. I'm a mother. I would never want this to happen to my children. I'm a father. I would never want this to happen to my family members. That may have helped just as much. But Susan, I just don't know.
Thanks, Jennifer. I agree. It's sometimes hard to understand what motivational causes are, but certainly all of the outcry and the hard work of the public to protest against this has been effective. I think that's true. So we have time for one more question. We have a question that says, let's see, do you have any concerns about Kelly's qualifier of separating mothers from children in cases of injury or illness?
Yes, 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 and yes. Great question. I thought it was a very unfortunate qualifier. I think what most of us wanted was a hard line, of course we won't do this, or no, we're backing off of it. I believe what was offered was I don't think I ever said that, which I think there's ample evidence that in fact he did say that this is something the agency was considering. But again, there are certainly going to be a discrete number of cases in which people are concerned about whether the parent is in a position to care for the child, or whether the parent has harmed the child, or whether the individual is actually the parent. And I don't think any of us are complaining about those cases where everybody's trying to take as much care as possible to make sure that the child is safe. What was proposed was a policy that had nothing to do with the children and parents who would have been affected, but was intended to send a message to others. The qualifier of we won't do this, but potentially in cases of injury or illness is awfully, from a lawyer's perspective, vague, broad, and open-ended. And certainly with respect to illness, I suspect that a lot of physicians would argue that it's generally better for a child to be in the presence or near a parent at a time when they are being evaluated for illness, and that it could be equally comforting to a parent to have their child nearby if they were the one who was ill. So again, I think it was concerning in that he didn't take it entirely off the table, which is one of the many reasons we were anxious to proceed with today's webinar, because I don't think the issue as a whole will be going away anytime soon. And the more that all of us understand about what's going on, and to the extent that any of you discover what it was that tilted the decision-making by Secretary Kelly, we would welcome your feedback so that we can all together advocate more effectively. Thanks.
Great. Thank you so much, Jennifer and Marisa. Thank you as well, and thank you all for joining us. That's all the time we have for today. We put up on this last screen here some contact information for additional questions you may have. Please do follow us on social media, and if you haven't already, sign up for our e-newsletter on the website. That's really the easiest way to get the most up-to-date information, and we'll be hosting webinars like this in the future. So thank you again, and have a great weekend, everyone.